If at first you do not succeed, try and try again. That has been the guiding mantra of the conservative legal movement for decades. Float a case before the Supreme Court, get a couple justices on your side, and then use their opinions as a guide to shop the nation for a case that gives the justices everything needed for them to finally take action. It is a strategy that actually predates the Trump era and this specific court, but became supercharged with this new conservative supermajority. Republicans waited for decades to overturn Roe versus Wade, bringing several unsuccessful cases before the court until finally succeeding last term with the Dobbs decision. And think about how Christian activists first brought the plight of a Colorado baker who didn't want to bake a gay wedding cake to the court in 2018, and then used a suggestion from Clarence Thomas that the case should actually have been considered on free speech grounds rather than a religious liberty test. 5 years later, we had the 303 Creative versus Ellenist decision, effectively making LGBTQ plus individuals second-class citizens. Now, that same cynical perseverance has now led to the gutting of affirmative action in college admissions. Since Roe was overturned, it is clear this court has no qualms about undoing long-established precedent. And believe me, there were mountains of precedent upholding the constitutionality of affirmative action in America, specifically because of the 50-year Republican project aimed at destroying that policy. So let's look at how we got to this point, because this is the playbook conservatives are using for anything they don't like or approve of, even if it takes decades to overturn and see those results. Affirmative action as a term actually entered the public lexicon back in 1935 with the Wagner Act, a federal law that gave workers the right to form and join unions. It was used to describe the process by which an employee would be given their job back if the National Labor Relations Board found they had been fired for union activity. John F. Kennedy was the first president to link the term specifically with policies meant to advance racial equality. And in the years after, the term started to be associated with education, a connection made thanks to the civil rights movement. The assassination of Dr. Martin Luther King Jr. in 1968 was a turning point. Students demanded their colleges redouble their efforts to have students and student bodies that actually better reflected American society. As the New York Times reports, less than 4 weeks after Dr. King's death, Harvard's dean of admissions at the time, he announced a commitment to enrolling a substantially higher number of African Americans. The following year's admitted class included a 76% increase in black students. And you better believe that conservatives immediately began gnashing their teeth. The first Supreme Court case challenging the constitutionality of affirmative action programs in education came just a decade later. In 1978, the Supreme Court heard Regents of the University of California versus Bake. At the time, UC Davis reserved just 16 out of every 100 admission spots for qualified minority students. Alan Bake, a white man, was denied admissions by the university's medical school despite having higher test scores than some minority students admitted that year, and he sued. And ultimately, the Supreme Court decided that the quota system UC Davis used was unconstitutional, but it also ruled that schools did have a, quote, compelling interest in the educational benefits of having a diverse student body, which allowed them to consider race in the admissions process, so long as it was one of many factors they were considering. Well, conservatives, of course, were outraged and spent decades shopping for the perfect self-described victim of affirmative action to bring future challenges. 2003, for example, conservative activists seized upon white people who were denied admissions to the University of Michigan and presented Gratz versus Bollinger and Grutter versus Bollinger before the court. Those decisions narrowed affirmative action policy slightly, making it illegal to use point-based systems with regard to race in college admissions. Yet in the end, the court again reaffirmed the constitutionality of the broader policy. So conservatives tried in 2013 and in 2016 with a white woman named Abigail Fisher, who was denied admission to the University of Texas again and again. The court ruled affirmative action was constitutional. Justice Kennedy, writing for the majority at the time, stated that the attainment of a diverse student body serves values beyond race alone, including enhanced classroom dialogue and the lessening of racial isolation and stereotypes. Affirmative action was both constitutional and a force for broader societal good that cannot be denied. But conservatives, well, they went back to the drawing board, continued shopping for the perfect plaintiffs, and returned to the court this past term with two cases: Students for Fair Admissions versus President and Fellows of Harvard College, and Students for Fair Admissions versus the University of North Carolina. By the way, that group named in both of those cases, Students for Fair Admissions, well, it's a right-wing activist group. Its lawyers argued that admissions programs at Harvard and UNC violated the Equal Protection Clause of the 14th Amendment by discriminating against Asian American applicants and providing favorable treatment to students from other minority backgrounds. And finally, John Roberts and his extreme colleagues said enough, deciding to end affirmative action as we know it. So this try and try again mentality, honestly, it's not going anywhere. As we said earlier, those of us who breathed a sigh of relief after the Supreme Court didn't end American democracy this past week with the Moore versus Harper ruling, well, they shouldn't rest easy. If we know anything, it's this conservative activist court has demonstrated time and time again, in fact, too many times now, that settled law isn't really settled in their eyes. It's just settled for the moment, not forever. And there will be another more perfect case to threaten democracy soon enough in this country.